So you're receiving this video because you've decided to sign up as a member of the Attorneys on Retainer Association, and this is part of the sign-up process. The reason we send you this video is because we want you to understand exactly what you're signing up for. So my name is Marc Victor. I am the owner and founder of the Attorneys for Freedom law firm, and we administer the Attorneys on Retainer Association. So I've been practicing law over 31 years, and the Attorneys for Freedom law firm has been in existence 28 years. And during that entire period of time, we've been representing people in major felony cases. And I can't remember a time when we weren't representing at least one or two people in a very serious crime where they were alleging self-defense as their defense to that crime. We're serious about doing self-defense cases. In fact, we're so serious about doing them that it's the only thing we do at our law firm. That's right. We don't accept any cases unless it's a self-defense case. And we are going to be the law firm that represents you if you find yourself charged with a criminal offense and you're claiming self-defense and the incident happened after you get signed up in the Attorneys on Retainer Association. So what we're going to do with this video is I'm going to review for you two really important documents. First, I have in front of me here a document that you are going to get at the end of the process, and it's entitled Attorneys on Retainer Association Membership Agreement. This is the agreement that you have with the Attorneys on Retainer Association. The second document we're going to review is the Legal Services Agreement for the Attorneys for Freedom law firm. That's right. You are going to have a separate agreement with the law firm because you are going to be a client of our law firm. So you will have an existing attorney-client relationship. That's right. We'll already have attorney-client privilege, and we have the duty to keep everything about the fact that we represent you and anything we do for you entirely confidential. That's right. No information about you or your background or any case that comes up goes anywhere other than the Attorneys for Freedom law firm. And it's all protected. Unless somebody's got a court order, they don't get anything, even the fact that you're a client of our law firm. All right, so let's get right into it. So the document in front of me is entitled, as I've said, Attorneys on Retainer Association Membership Agreement. Here's what it says. This membership agreement, the agreement, is made and entered into by and between the Attorneys on Retainer Association, that's AOR, and the undersigned individual or family member, that's you, you're the member. By joining AOR, the member agrees to the terms and conditions as set forth below. First, we have the membership levels and fees. First, there's the individual membership. If you're signing up as an individual membership, it's a $100 one-time sign-up fee and $35 a month. If you want to pay the annual membership all at once, you get a discount. It's $357 for the year. The other possibility is you're signing up on the family membership, which is 2 or more people. The way this works is each member of the family plan pays $75 one-time sign-up fee per family member, and you get a discounted rate. Instead of the $35 a month, each member of the family plan pays $25 per month, that's per family member, or if you decide you want to pay it up for the year, you get the same discount, essentially 15% off, $255 a year. That's per family member. I want to say something right here. You got to get signed up right away because these prices are definitely going up. The good news is because you're signing up right now, assuming you get it done right now, you are going to be grandfathered in at this pricing until January 1st, 2030. That's right. We might add some new things down the road that you can opt for and pay additional if you want, like maybe higher levels of coverages and things like that. But if you stick with this plan right here, you are going to be locked in at the rates that you're paying right now. That's why it's important for you to finish the sign-up process. Okay, the next section says membership benefits. All members of AOR automatically receive the following benefits. Number one, attorney-client relationship with the Attorneys for Freedom Law Firm, which we abbreviate as AFF, Attorneys for Freedom. Okay, here's what it says. All AOR members immediately establish an existing attorney-client relationship with AFF. Now, there's a footnote here. I want to read you the footnote. Subject to a conflicts check, confirmation of fee agreement video review, that's the video we're doing right now, client's confirmation of no additional questions, and fully executed law firm fee agreement received by AFF. What that means is at the end of this video, you're going to get an option to let us know if you have questions about any of this that we're talking about here today. If you do, you'll check the box, and then somebody from my team will reach out to you to schedule a time for you to talk to either me or one of my lawyers to answer your question about the Attorneys for Freedom Legal Services Agreement. If you check the box that says you don't have any questions, no problem. You've watched the video, you've checked the box. As long as we don't have any conflicts, and we probably don't, if we do, we'll let you know, then boom, you're a member of the Attorneys on Retainer Association. Okay, continuing on. Member is strongly encouraged to complete the attached confidential emergency information form, which should be sent directly to AFF via members' individual secured online portal. Let me stop right there. The confidential emergency information form. If you don't have that already, you're going to get it very soon. You're going to have a secured portal so we can communicate back and forth in a confidential way. Why do we want you to fill out this form? Because if we have an emergency and we can't get a hold of you, like maybe you were just arrested and you're in the police car and you're on your way to the station or to the jail or something like that, we need information so we can have that attorney ready to go for the release hearing. Because we're a law firm and this is what we do. We already know what it is the judge is going to want to know at that release hearing. This gives us some background information. Don't worry about it being used for any other purpose. We're a law firm. Again, it's all subject to attorney-client privilege and the duty of confidentiality, which means we can't use it for anything. Nobody gets that information. If you don't give us that information, then if you call us in an emergency, we won't have that information. It'll put you at a disadvantage. So little tip, fill out that form and send it back to us. Okay, continuing on. All member information, including all information on the confidential emergency information form, is received and retained solely by AFF and is strictly protected by the attorney-client privilege and the ethical duty of confidentiality. No member information is provided to RRG, which stands for the Risk Retention Group. We could talk about that a little bit later, but that's in essence a different entity that issues a risk retention group policy to members of the Attorneys on Retainer Association. But no member information is provided to the RRG or to the AOR Association or any other person or entity without a court order. You want attorney-client privilege and confidentiality. That's why you're signing up in the AOR Association, because you want a real law firm on standby, ready to go. So you have that with the AOR program. AFF securely retains all information about all AOR members, including name, address, and any other information in accordance with the rules of professional conduct. Okay, so that should be pretty clear. You're going to have a relationship with the Attorneys for Freedom law firm right from the beginning. Number two, 24/7, 365 emergency legal advice. Here's what it says. Immediate 24/7, 365 access to AFF attorneys for urgent attorney-client privileged legal advice in self-defense related legal matters. AFF attorneys will immediately commence legal representation as needed for all self-defense related legal matters. Okay, that's pretty clear. If you have a problem, you call the emergency hotline, which we staff with lawyers from our firm and paralegals. If you haven't heard about the strike force, there's probably some videos kicking around that detail exactly what our strike force is. But we take that emergency line very serious. You could call us any day, anytime. You're going to be on the phone very quickly with me or Andy or one of my lawyers. So that's what the 24/7, 365 emergency hotline is about. Number three, the Attorneys for Freedom Risk Retention Group, Inc., that's the RRG policy, which we abbreviate here as the policy. Here's what it says. All AOR members are automatically covered as insureds pursuant to the RRG policy, which provides comprehensive, effective legal representation in all 50 states, including Washington, D.C., in the event of a self-defense-related legal matter. All RRG policy coverage determinations are resolved exclusively by AFF. That's right. If you have a claim, that entire policy is administered not by some third party somewhere, but by us here at the Attorneys for Freedom law firm. All legal services are provided by AFF and local counsel as needed, and all funding is paid for by RRG, subject to the terms and conditions in the RRG policy. There are terms and conditions, right? There's the three big ones. It has to be an incident that either gets you charged with a crime or concerned about being charged with a crime. The incident has to have happened after today, assuming you continue on with the sign-up process, and you got to be able to claim self-defense as a defense to that legal charge. Those are the three things that you need to show in order to get coverage on a self-defense legal matter. Okay, number four, self-defense training videos and other miscellaneous benefits. All AOR members will receive online training videos relevant to self-defense and firearms issues. All AOR members will receive additional benefits, which may include discounts on firearms, ammunition, and related items, the opportunity to take advantage of discounts on advanced firearms and self-defense training. AOR anticipates funding litigation to vindicate the constitutional rights of firearms owners and other pro-freedom related issues. Okay, what's this about? The AOR Association does lots of different things. It provides training for its members, firearms-related training, self-defense-related training. We'll get you some discounts on things. There'll be a host of other things for developing your business interests if you want to make some money promoting the AOR Association to friends or other people. And we're going to advocate for your constitutional rights. That's right. We're going to bring cases that vindicate your constitutional right to keep and bear arms, among other constitutional rights, right? We're the Attorneys for Freedom, and we defend all freedoms of all people at all times. So look forward to cases that we're going to bring on behalf of the members of the Attorneys on Retainer Association. This allows us to advocate for freedom, which is what we want to do at the Attorneys for Freedom law firm. Okay, number five, periodic video newsletters. All AOR members will receive via email periodic video newsletters containing legal insights and commentary on developing case law and other newsworthy items relevant to self-defense issues of general interest to AOR members. Additionally, AOR members will receive AOR news and other self-defense and firearms-related information. So look for us to send you an email newsletter. It's going to have lots of information. You'll get to know me, the other lawyers at our law firm, breaking news, Supreme Court cases, other issues of interest to people who are interested in the firearms and self-defense and pro-freedom community. These are our AOR members in the association. That's our way to communicate with you, breaking information. Number 6, commercial affiliate status. Here's what it says. All AOR members are automatically afforded commercial affiliate status to earn income by introducing AOR membership to other potential members who enroll in AOR. Okay, there's a footnote here. Here's what it says. Terms and conditions apply, which will be provided separately. So there's a bunch of details here for you to get started as a commercial business, as an affiliate of AOR, that'll detail information we need from you about how do we pay you, tax-related information, all of this information. You will get that separately after you join. Each AOR member will have a unique URL link to share, which will tally enrollment numbers of resulting new AOR members. That's how we find out the people who you've enrolled. You'll give them a link. They click that link. It will send them to the website. It will tell us that this is somebody you referred, and this is how you get paid when you tell other people about the AOR Association. Marketing support is also available to all AOR members, including additional training regarding business and personal development and networking opportunities. So all that is part of your status as a commercial affiliate. There's a way to make money here. You really should take advantage of it, but only do it if it's in your heart. We got to sell you on the Attorneys on Retainer Association, and we're up for that challenge. We think this is definitely going to be a win for you. It'll be a win for us, and it will be a win for people you introduce to the AOR Association as well. 7, AOR Conference Invitation. Here's what it says. All AOR members receive an invitation to the periodic AOR National Conference to interact and familiarize themselves with AFF attorneys, attend formal presentations on issues relevant to self-defense or firearms law, and network with other AOR members and vendors of interest to AOR members. All AOR members are eligible to attend for free via the internet. Discounted ticket pricing applies for AOR members who wish to attend the conference in person. If you missed our last conference, you really missed a good time. There were lots of food, lots of fun, lots of opportunities to interact with me and my lawyers, and it was great for us to get to know you, our clients. So if you can come in person, you're definitely going to get a discounted ticket. I encourage you to come in person. We want to get to know you. We want you to get to know us. We did firm tours last year. It was a big hit. People love our law firm. We want you to know who your lawyers are going to be, and we want to get to know you. So we've got some amazing clients as well. But if you can't attend in person, you'll be able to attend via internet so you can catch all of the presentations. Okay, next category, it says membership benefits for self-defense related legal matters. Here's what it says. If an AOR member in good standing satisfies the following 3 criteria, here they come. Number 1, member is charged with or reasonably concerned about being charged with any state or federal criminal offense. Felony, misdemeanor, doesn't matter. Number 2, the incident giving rise to the alleged or potentially alleged criminal offense entirely occurred after becoming an active AOR member. In other words, if you got something pending before you signed up here today, it's not going to be covered under this program. But if it happens after today, then if it meets these 3 criteria, you're covered. Number 3, Self-defense or defense of a third party can be asserted in good faith as a legally sufficient, complete defense to the alleged or potentially alleged criminal offense. Okay, you got to be able to argue self-defense for this to apply, but those are the three criteria. So continuing on, here's what it says. Then the member is entitled to the following benefits pursuant to the RRG policy. And there's a footnote here that says, see RRG policy for specific language. This is a summary of the RRG policy. Now you're going to get the RRG policy. We're going to send it to you as part of your sign up. You can read it yourself. No problem. If you have questions about it, let us know. But we're also going to do a video where I'm going to take you through the main highlights of the RRG policy. We got nothing to hide. We're transparent, and we want you to know what's in that policy. So look for that other video and look for the RRG policy so you can read it for yourself if you are interested. Okay, number one, criminal and civil defense. Pursuant to the terms and conditions of the RRG policy and separate agreement between RRG and AFF, which is the RRG entity and the Attorneys for Freedom law firm. All legal fees are covered to defend the criminal and related civil case up to and including trial with no financial limit. Okay, there's a footnote here. Legal fees are based on legal representation by AFF or such other qualified attorney if AFF is not able to represent the AOR member due to legal conflict or other reason. I don't think we're going to have a conflict, but if we do, if there's some reason we can't represent you, then we will provide you with another attorney, somebody who you prefer, who is qualified to do the case. Number two, civil liability coverage. You get up to $100,000 for civil liability coverage in the event of a final civil judgment against an AOR member resulting from a covered self-defense related legal matter. On this point, there's a footnote. There may be higher limits available if you want to pay an additional fee to get more than $100,000 coverage. We expect to have that available. Andy and I are going to do a video at this point because it might make sense for you to have higher limits. It also may not make sense for you to have higher limits. And we're going to walk you through that thought process so you're fully informed and you can make a rational decision here about what's best for you. Number three, expert witness and investigator fees. All necessary expert witnesses, investigators, and court fees, excluding fines, are covered. You don't have to worry about any of this. You're going to get a defense from us with local counsel that's going to cover your criminal case, your civil case. You don't have to worry about any coverage limits on the defense. And we're going to get the best expert witnesses we can possibly get and investigators on your case. Because if we're playing here, we want to play to win. So don't worry about that. It's all covered. Number four, appeals. All legal fees are covered for any necessary good faith appeals with no financial limit. So if things don't go the way we want and you choose you want to appeal and you get to make that decision, we will defend you and prosecute that appeal for you. No limit on attorney's fees here. Five, bail bond assistance. Coverage for necessary cash or secured bail bond up to $50,000. But again, a footnote, higher limits may apply. There's likely to be options down the road. If you want to raise that bail bond assistance from $50,000 to something higher, stay tuned because we will likely have an option for you. Number six, psychological counseling, up to $1,500 for psychological counseling. Don't overlook this. If you get involved in a self-defense related incident, this is going to be more stressful than you're expecting, and you probably want to talk to somebody here. Some of our past clients have taken advantage of this benefit. It's been a huge help for them. We have people we've worked with. We'll make recommendations here, but if you need that, it's available for you. Number seven, scene cleanup. up to $4,000 for scene cleanup of AOR member's home or vehicle, kind of self-explanatory. 8, firearm reimbursement, up to $1,000 for firearm reimbursement. 9, red flag protection orders. A lot of people asked for this. We now include red flag protection orders. Here's what the footnote says on that. While the 3 criteria above need not apply, all allegations giving rise to the red flag protection order must have entirely occurred after becoming an active AOR member, and the protection order must specify that the AOR member cannot possess firearms. Okay, if you think about it, the red flag, this has nothing to do with self-defense, so those are different criteria. But if you meet the criteria here for the red flag, the thing happened after you signed up, and the judge says no guns for you, no problem. We've got up to $15,000 to pay a local attorney to handle that red flag. We've done many of these. None of them that I can think of in my time practicing law have exceeded $15,000, so that should be plenty adequate to handle your red flag matter. 10, victim representation. Here's what it says. All legal fees with no financial limit are covered to represent the AOR member as a victim if criminal charges are filed against another person identified as the defendant resulting from the same self-defense related incident. Okay, what's this about? Look, to my knowledge, no other program offers this. Imagine you're in a self-defense related incident and you don't get charged, but they charge the bad guy, or maybe they should charge the bad guy and haven't yet. No problem. You call us, we're gonna represent you as your lawyer as a victim. We're going to do our best to try to convince that prosecutor to charge that person so they become the defendant and you're the victim in their criminal case. And if that happens, we'll show up in court and pound that lectern and ask and argue for whatever sentence you think is appropriate for that person. We can also argue about whatever plea offer is offered to that defendant. We've done many of these. We're happy to do it. It's part of the AOR program. Continuing on, number 11, expungement of criminal record. If available in the relevant jurisdiction, up to $5,000 for legal fees to set aside or expunge any covered incident. Look, imagine you get charged, you get prosecuted. Say we go to trial, we win, you're acquitted. There's still a record here that you were arrested, that you were charged. We want to do everything we can do to clean up that record. Not all states allow this, but if your state allows this or the state where it happened allows this, we will advocate for you. You get up to $5,000, which shouldn't be more than that, for us to file the appropriate documentation, maybe go to a hearing to advocate for either an expungement or a set-aside, depending on the relevant jurisdiction. Okay, next, conditions that do not operate as exclusions. This is my favorite section, things that are not excluded. Again, this is one of the things that makes the AOR program very different than any of these other programs. Here's what it says. The following specific circumstances are not exclusions to coverage in the RRG policy. A, the act of self-defense is ultimately determined to be imperfect self-defense, illegal conduct, or a criminal act. Again, not excluded. B, the act of self-defense involved a negligent, accidental, or unintentional discharge. C, the act of self-defense occurred while the AOR member was impaired by alcohol or any other drug. D, act of self-defense involved an illegal weapon. E, act of self-defense involved no weapon or a weapon other than a firearm. No problem. F, act of self-defense occurred at a place where firearms were legally prohibited. G, act of self-defense involved a person who was in a domestic relationship with the insured. No problem. H, AOR member did not possess a concealed carry permit or possessed an expired concealed carry permit. I, act of self-defense occurred while the AOR member was a prohibited possessor. And J, act of self-defense was not a threat or use of deadly physical force. None of these are exclusions in the RRG policy. Now, it's important to note the RRG policy has its own language. And if you watch that video or you review the RRG policy, you might note that an act of self-defense is called something different in the RRG policy. It's called an occurrence related to association training. It means essentially the same thing. And in that video where I go through the occurrence related to association training definition, you'll see it's defined in exactly the same way an act of self-defense is defined. Moving right along, next section, additional terms and conditions. Number 1, termination of membership. Here's what it says. Any member may terminate their AOR membership at any time for any reason or no reason at all, merely by notifying AFF, either orally or in writing. Okay, that couldn't be easier. You don't want to be in the AOR program anymore? No problem. You let us know. You're going to get no aggravation from us. If it's not a win-win deal, which means win for us and win for you, we're out. We don't want to do the deal if it's not a win for you. So if it ever turns out it's not a good fit for you anymore, no aggravation. You just let us know you want to cancel the program. We don't even care what the reason is. We may ask you because it might be an opportunity for us to improve, and we're always looking to improve. But it doesn't matter what the reason is or if there's no reason. If you want out, you can cancel anytime. Any such termination shall be effective immediately. Monthly membership fees are non-refundable. Annual membership fees will be prorated in monthly increments. Okay, so if you've already paid the monthly fee, if you're on the monthly program, it'll be effectively terminated at the end of the month. If you've paid an annual membership and you paid it all up, we're going to prorate the refund. We're doing what's fair and just. If you want out, you can get out. AOR may terminate any member's membership in AOR for non-payment of membership fees, continued abusive conduct to any member of AFF after a written warning, or continued abuse of the 24/7, 365 emergency hotline after one written warning. Okay, so if you go afoul of either of these things, you'll get a warning from us. We'll let you know if we think you did something that was abusive to somebody here at the firm. You'll get a warning. Or if you did something abusive regarding the hotline, which is essentially, oh, I just called the hotline to say hello and see how you guys are doing. Look, we have a very serious strike force. We take those phone calls very seriously. The entire team mobilizes. Don't just call us at 3 o'clock in the morning on the hotline just to test the hotline. You got a real emergency, don't hesitate, you call us. But if you call us and it's an abuse of that hotline, we're going to say, hey, look, you abused the hotline. We're going to give you a written notice. If you do it again, we drop you out of the program. I think that's fair and reasonable. 2, non-transferability. AOR membership is personal to the member and cannot be transferred or assigned to any other individual or entity. That seems obvious. Number 3, another one of my favorites. Here's what it says. No recoupment clause. The RRG policy contains no recoupment clause. As such, under no circumstances will RRG request any refund of legal fees, expenses, or costs from any AOR member expended for any purpose other than RRG funds used to post any bond, and only upon exoneration of that bond. Okay, so unlike many other programs, we never ask for recoupment. Anything we've paid out, that's the end, with the one exception of bond. If we put money up for your bond, once that bond is exonerated, okay, you don't get to keep that money. The RRG gets that money back. But there is no recoupment clause, unlike many other programs. You probably already know that. That's why you're signing up in the Attorneys on Retainer Association. Number 4, membership renewal. The term of this membership is 1 year, starting on the membership effective date, which is the date accepted by AOR and AFF. This endorsement and its coverage will automatically renew for successive one-year terms, so long as the member maintains the AOR membership in good standing and as further set forth in the RRG policy. By signing this agreement, member authorizes regularly scheduled charges to member's credit card pursuant to the terms of this agreement. Member will be charged an amount consistent with this agreement for each billing period. A receipt for each payment will be provided to member, and the charge will appear on member's credit card statement. Member agrees that no prior notification will be provided unless the date or amount changes, in which case the member will receive written notice from AFF at least 10 days prior to the payment being collected. Okay, so that's all pretty self-explanatory. Whatever the deal is you're striking with us, we're going to continue to renew that deal unless and until you tell us you want out. 5, member obligations. Members' responsibilities and obligations include keeping contact information up to date, timely paying membership fees, and cooperating fully with AFF or any other law firm approved by member and AFF. Okay, that seems pretty obvious. Number 6, data privacy and confidentiality. AOR does not retain any personal information about any member. Okay, that's the association. The association does not retain any personal information about any member. Instead, all information about all AOR members is retained by AFF, the law firm. So attorney-client confidentiality rules apply, and attorney-client privilege attaches to the extent permitted by law. AFF, the law firm, does not release any information about any member for any purpose unless pursuant to a court order. That's the reason we set it up this way. So you would have attorney-client privilege and confidentiality solely with the law firm. Nobody else gets any information. Not the RRG, not the AOR Association. 7, specific RRG policy details. Here's what it says. Attached hereto is a copy of the RRG policy. Okay, I've summarized the main points, but you are also, as I've said, going to receive the entire RRG policy. There'll also be a video of me explaining the RRG policy. If you have any questions about that, you let us know. We're happy to answer any questions you have. Transparency, it's really important to us. Number 8, disclosures. See the AFF retainer agreement attached hereto for file retention policy. Okay, I'm about ready to go through that as soon as I finish this. That's the Attorneys for Freedom Legal Services Agreement. Stand by, that's coming up next. AOR, the association, is a 501c6 nonprofit association separate from AFF, the law firm. AOR, the association, wholly owns the RRG, the Risk Retention Group, which is called the Attorneys for Freedom Risk Retention Group, Inc. That's right, the Attorneys for Freedom created it. We created it. We wrote the policy. While some AFF attorneys may serve in advisory or board positions with AOR, the association, as a nonprofit entity, no AFF attorney, other person, or entity has any ownership interest in AOR, the association. That's because it's a nonprofit association. Nobody owns it. RRG is obligated by agreement to pay for all covered self-defense related legal services that AFF provides to member and costs incurred in representing member pursuant to the RRG policy. This agreement to pay for attorney's fees and costs does not render RRG a client of AFF, the law firm, and an attorney-client relationship exists only between AFF, the law firm, and you, the member. RRG will not interfere with the attorney-client relationship and will not interfere with AFF's exercise of independent professional judgment on behalf of any member. In other words, the RRG doesn't get to get in between the law firm and you. They don't get to make decisions. We make all the decisions. There is no third party, anyone else working at the RRG or the association. It's all administered by the law firm. But we've put this language in here to make it very clear that the law firm does not represent the RRG. The law firm represents you. In furtherance of the independent nature of the attorney-client relationship, RRG has no right to direct or have access to any information about AFF's handling of any member's legal matter. Look, we know you want attorney-client confidentiality. You don't want your information going anywhere besides the law firm. That's why we set it up this way. All right, number 9, governing law. This agreement shall be governed by and construed in accordance with the laws of the state of Arizona. 10, exclusions and limitations. The RRG policy details specific exclusions, and that'll be in the RRG policy. 11, severability. If any provision of this agreement is found invalid or unenforceable, the remaining provisions shall remain valid and enforceable. 12, entire agreement. This agreement constitutes the entire agreement between the parties and supersedes all prior agreements and understandings, whether written or oral, relating to the subject matter thereof. 13, acknowledgement and authorization to charge credit card. Here's what it says. By signing below, member acknowledges that they have read and understood this agreement and agreed to be bound by its terms and conditions. Member understands and acknowledges that no legal advice was provided to them regarding entering into this agreement or with respect to the RRG policy or engagement with AFF. Member is encouraged to read the terms carefully and consult an attorney if they have questions. By signing below, member confirms they understand and agree to the terms of this agreement. Further, member authorizes AOR to charge member's credit card pursuant to this agreement on a monthly or yearly basis. Such payment will satisfy members' AOR monthly or yearly fee pursuant to this agreement. By signing this agreement, member understands this authorization will remain in effect until member cancels the AOR membership or revokes this authorization to substitute an alternative form of payment. Member acknowledges that all credit card transactions must comply with all provisions of law. Member certifies that member is an authorized user of the credit card to be used and will not dispute these scheduled transactions so long as the transactions correspond to the terms indicated in this agreement and authorization. Okay, there's a place for you to put your name, sign, date. There's information here for us to sign, information at the bottom, contact, how you get a hold of us, which is the phone number, and support for the AOR Association. That is the contract, the Attorneys on Retainer Association Membership Agreement. Okay, you're going to be presented with a box to check about whether you have questions about this agreement or whether you understand it. You'll have to decide and make that determination. If this makes sense to you, because I've read it all, then check the box that says you've read the agreement, you understand the agreement, you don't have questions. Okay, having just finished the contract between you and the Attorneys on Retainer Association, I am now going to start to review the contract between you and the Attorneys for Freedom Law Firm. That's a separate contract, and it's entitled Attorneys for Freedom Legal Services Agreement. And here's what it says. This document confirms the terms and scope of our legal representation of you. That's where your name goes. You're referred to as either client or you in this agreement, pursuant to the policy issued by the Attorneys for Freedom Risk Retention Group, Inc., abbreviated as RRG, to the Attorneys on Retainer Association, abbreviated as AOR, through which you are covered for certain legal services and legal fees. You understand that the Attorneys for Freedom Law Firm, AFF, is being paid by RRG, pursuant to the RRG policy, which automatically covers all members of the AOR Association. Okay, number 1, scope of the agreement. Here's what it says. Section A. Scope of this agreement is limited to securing the legal services of AFF for limited scope legal representation and related costs and expenses in the event you are either charged with or reasonably concerned about being charged with a crime as a result of an incident as that term is defined in the RRG policy. AFF's representation of you is limited to defending you in such a self-defense related legal matter, as well as presently establishing an attorney-client relationship with you for the purpose of receiving confidential and attorney-client privileged information contained on your confidential emergency information form, in rendering legal advice relating to any self-defense related matter in an emergency. Neither this agreement nor the RRG policy covers unrelated criminal charges or counterclaims against anyone, nor will AFF advise you on any dispute that you might have either with the RRG or with the AOR Association regarding coverage of the RRG policy. Okay, B, you understand that attorneys working at AFF may have some management and or control interest in either or both RRG or the AOR Association. If there's any dispute regarding coverage of your legal fees pursuant to the RRG policy, an independent third party will resolve that dispute, and AFF shall not represent you, RRG, or the AOR Association in any aspect of that dispute. If at any time AFF believes the interests of RRG as a third-party payer of your legal fees are in conflict with your interests, AFF will notify RRG it should retain counsel to advise it. AFF shall not provide any information to either RRG or the AOR Association about you or any legal matter involving you. As I've said repeatedly, all information about you or any case you have stays right here at the Attorneys for Freedom law firm, and that's so we can preserve attorney-client privilege and confidentiality. Okay, part 2, legal fee. Here's what it says. Pursuant to the terms of the RRG policy, RRG shall pay all legal fees, expert witness fees, and investigator fees for any incident leading to a covered self-defense related legal matter, including, but not limited to, the fees for co-counsel retained to assist you with representation. By signing this agreement, client gives informed consent to have RRG pay your legal fees for the scope of representation as set forth above. Pursuant to Ethical Rule 1.8F, neither RRG nor AOR, the association, is authorized to direct any aspect of AFF's representation of you. Nothing gets in between the attorneys at the Attorneys for Freedom law firm and their representation of you. That's what it says here. 3, additional terms, definitions. An incident is defined as a client's act of self-defense that either results in a civil or criminal charge or case against a client, or results in a client being reasonably concerned about a civil or criminal charge or case being brought or instituted against the client. That's what an incident is. An act of self-defense is defined as the actual or threatened intentional use of physical force by the client to protect any person. A self-defense related legal matter is defined as a matter that satisfies each of the 3 criteria below. These are going to sound familiar to you. Number 1, client is charged with or reasonably concerned about being charged with any state or federal criminal offense. Number 2, the incident giving rise to the alleged or potentially alleged criminal offense entirely occurred after becoming an active AOR member and client of AFF. And number 3, self-defense or defense of a third party can be asserted in good faith as a legally sufficient complete defense to the alleged or potentially alleged criminal offense. Same 3 criteria that we just went through in the AOR Association document, and it's the same criteria that's involved in the program and has always been involved in the program. B, excluded matters. Any matter that does not satisfy each of the 3 criteria in Section 3 above, which I just went over, is not a self-defense related legal matter pursuant to this agreement. Any matter that arises wholly or partially from any event that occurred prior to the effective date of this agreement is not a self-defense legal matter. The date upon which any formal criminal charges are filed is irrelevant and inapplicable to the analysis of whether a criminal charge constitutes a self-defense related legal matter. Okay, what does that mean? Look, you might have had an incident that occurred 6 months ago, and you might get charged 6 months from now. Just because you're signing up today doesn't mean this incident is covered. Everything that happened during that incident that gives rise to the criminal charge or the concern for a criminal charge has to have happened after today's date, assuming you finish the sign-up process today. C, additional considerations. If a matter otherwise qualifies as a self-defense related legal matter pursuant to Section 3 above, the following circumstances shall not operate to deny legal representation pursuant to both the RRG policy and this agreement. All right, you're going to get the same parade of things that are not exclusions. Why did we put it in? Because we want it to be very clear. It's in both the AOR Association contract and the AFF Legal Services Agreement. We're proud of the fact that we do not exclude these things. Here it comes. The assertion of self-defense is ultimately determined to be imperfect self-defense, illegal conduct, or a criminal act. Not excluded. The act of self-defense involved a negligent, accidental, or unintentional discharge. Act of self-defense occurred while the client was impaired by alcohol or any other drug. Act of self-defense involved an illegal weapon. Act of self-defense involved no weapon or a weapon other than a firearm. Act of self-defense occurred at a place where firearms were legally prohibited. Think about sensitive places here. The act of self-defense involved a person who was in a domestic relationship with the client. Client did not possess a concealed carry permit or possessed an expired concealed carry permit. Act of self-defense occurred while client was a prohibited possessor. Act of self-defense was not a threat or use of deadly physical force. Okay, none of those things are exclusions. That's right. Even if it turns out ultimately it was a criminal act, which means you wind up taking a plea, you wind up being found guilty at trial, that doesn't operate to deny coverage, right? Unlike some of the other programs where if you take a plea, you might lose your coverage. Not a problem with the AOR program. And we wanted to have that in both the legal services agreement, your agreement with the firm, and your agreement with the AOR Association. It's also in the RRG policy if you take a peek at that. Okay, D, conflicts. Given that AFF represents no state or federal agencies, AFF expects no conflicts of interest in any self-defense related legal matter. However, if there are multiple co-defendants or victims in the same self-defense related legal matter who are also AFF's clients, a conflict could arise. In the extraordinarily rare event of a non-waivable conflict of interest, which prohibits AFF from engaging in legal representation in the self-defense related legal matter, RRG shall retain and pay for substitute legal counsel in consultation and deference to client's choice of substitute legal counsel. What does this mean? It means if we've got some conflict and we can't represent you, then the RRG policy will consult with you, decide on an attorney that you're happy with, and pay for a substitute lawyer to represent you. Unlikely that this is going to happen, but even if there was a conflict, you're not left high and dry. You will still have a qualified attorney. Subsection E, additional charges. In the event that there are additional criminal charges brought in the same matter, along with any self-defense related legal matter, AFF will determine whether the additional criminal charges arise out of the same conduct as the self-defense related legal matter. If so, the legal fees for representation on the additional criminal charges will be included as part of this agreement. However, if the additional criminal charges do not arise out of the same conduct as the self-defense related legal matter, they are considered unrelated. In such an event, client will be given the option to retain AFF under a separate agreement at AFF's normal hourly rate, discounted by 35% for representation as to the unrelated criminal charges, for which client will be responsible for paying those legal fees, not RRG. In such an event, client will be required to deposit a retainer amount into AFF's trust account. If AFF and client cannot mutually agree on an additional fee for legal representation for the unrelated criminal matter, AFF shall have the right to decline representation pursuant to this agreement. AFF cannot represent a client on some criminal charges, but not others in the same criminal matter. Okay, look, if it's the same criminal matter and you get the self-defense charges and other charges that are not self-defense, but they arise out of the same conduct, no problem. It's going to be handled. But if some prosecutor put this incident, the self-defense incident, together with an unrelated incident with unrelated charges, all right, you're going to have to pay some for that. This is very unlikely to occur. If it does happen, we'll talk to you about it. We'll do our best to come to a win-win. We certainly don't want to leave anybody hanging on these. But on the other hand, we don't want to represent you on an unrelated case for free. In essence, that's not a self-defense related legal matter. All right, hopefully that's clear. Section F, trial court level. The trial court level includes all legal representation commencing from the client's initial contact with AFF, informing AFF of the self-defense related legal matter through either a dismissal, an acquittal, or a sentencing. AFF's legal representation in any covered self-defense related legal matter will continue regardless of whether any policy limits contained in the RRG policy have been exhausted. All right, what this means is we start representing you from that first phone call. As soon as we know about the self-defense related incident, we're on the case, and we're going to represent you the entire time through the trial level. If you go to trial, we'll represent you. You don't have to wait to start the trial for us to start representation. We start right from the first phone call. And while you'll notice there are limits in the RRG policy, you'll see in the RRG policy by separate agreement if those representation cost of defense limits have been met out of the RRG, then the Attorneys for Freedom Law Firm will continue to represent you with no limit on attorney's fees through that trial level till everything is resolved. And then we get to G, appeals. If an appeal becomes necessary as a result of any covered self-defense related legal matter, AFF agrees to accept the appellate representation at no additional cost to the client. AFF will continue to represent the client in any retrial, after a mistrial, or successful appeal. AFF's representation in any covered self-defense related legal matter will continue regardless of whether any policy limits contained in the RRG policy have been exhausted. So don't worry about capping out on any attorney's fees, either at the trial level or at the appellate level. We will handle it and see it through to the end. Also H, civil defense representation. If AFF is retained by RRG, AFF agrees to represent the client in the event client is sued in a civil court of general jurisdiction as a result of any covered self-defense related legal matter. In such an event, AFF will represent the client in their civil defense with no additional attorney's fees, commencing from the client's initial contact with AFF, informing AFF of the civil lawsuit through and until either a dismissal, settlement, judgment, or verdict in the trial court. Additionally, as to all covered civil matters resulting from a self-defense related legal matter, RRG shall be responsible for any additional expenses as detailed in this agreement, including any pro hoc vice fees or travel expenses, any payments toward any resulting civil judgment, whether arising from a settlement or litigation, will be paid by RRG pursuant to the terms of the RRG policy. All right, to summarize that, same on the civil side. If you get sued as a result of a self-defense related incident, we're going to defend you with no limit to the legal fees, and you have that coverage up to at least $100,000 from the RRG to pay any judgment that results. So if you decide to settle the case and it's under 100, RRG is going to pay that freight on it. That also includes the experts and the pro hoc vice fee and the travel expenses on the civil side, just like it does on the criminal side. What we intend here is a complete legal defense on both the criminal and the civil side for any self-defense related incident. Okay, I, On duty. In the event a self-defense related legal matter arises out of events occurring while on duty, acting in any capacity as law enforcement, security, or other protective services, this agreement shall be supplementary and secondary to any other agreement, insurance, or coverage the client has or is provided for legal representation. All right, look, if you're on duty and somebody else has got a policy out there, say you're a police officer and you're on duty and you get involved with an incident, you get charged with a crime, and your fraternal order of police or the department or the city or something, they provide an attorney, we'll still get involved and work with them, but we're secondary. If they don't, then we'll step up and handle the situation. That's essentially what that section says. J, AFF is ethically bound not to represent clients engaging in bad faith litigation, including frivolous legal matters, positions, or defenses. As such, AFF shall be the sole judge of what matters are asserted in bad faith or are frivolous. If AFF determines any legal matter, position, or defense is engaged in bad faith or is frivolous for any reason, AFF will either not accept representation or will withdraw from the case. However, if the client's honest recollection of the events giving rise to a self-defense related legal matter are sufficient to allow self-defense or defense of a third party to be argued to a jury, AFF will conclude the matter is not frivolous. All right, what's J mean? No lawyer can bring any matter that is brought in bad faith or is frivolous, period. All lawyers have ethical responsibilities, and that's one of them. So we can't just bring a matter in bad faith or that's frivolous. However, if your honest recollection of the event is sufficient to support an assertion of self-defense, or said another way, if we can argue self-defense to the jury, no problem, it's not frivolous. But we cannot violate the ethical rules, nor can any other lawyer. And we either comply with or exceed all ethical rules. Section 4, costs and expenses. Subsection A, RRG shall be responsible for all costs and expenses as reasonably necessary to effective legal representation for covered self-defense related legal matters only. Costs and expenses include the following: court costs and all official fees, witness and consulting fees, court reporters, expert witnesses, investigators, polygraph examinations, DNA examinations, and other scientific tests, fees related to discovery, departmental reports, medical records, transcripts, process servers, messenger services, appraisers, escrow agents, accountants, electronic research, Westlaw, photocopies, postage, and any other expense in which, in the judgment of AFF, are necessary to effective representation. RRG is paying all those costs and expenses. Section B, pro hoc vice. RRG shall be responsible for any pro hoc vice fees as well as all necessary travel expenses unless otherwise agreed to by the client. AFF shall handle any trial, substantive, evidentiary, or suppression hearings or contested sentencing hearings in any covered self-defense related legal matter. In AFF's sole discretion, AFF may opt for any pro hoc vice counsel to personally handle any routine hearings, including arraignment, pretrial conferences, scheduling conferences, case management conferences, status hearings, discovery-related hearings, or stipulated sentencings. Okay, what does this mean? It means RRG is going to pay the expenses for pro hoc vice. How are we going to divide work? The attorneys at the Attorneys for Freedom law firm, we're your main lawyers. We're first chair on the case. We're going to handle all the substantive stuff. If it's routine stuff, and lots of times in a criminal case, the hearing is, hey, judge, we're still working on this and that. We're waiting for discovery. We're waiting for interviews. Judge says, okay, see you in 30 days. Pro hoc vice counsel or local counsel may handle that type of a hearing. That's what that section is about. Section 5, other provisions. The client understands that the lawyers at AFF are currently admitted to practice in Arizona. However, AFF routinely appears as counsel of record in other states by the operation of that state's pro hoc vice rules. AFF has appeared pro hoc vice in many other states on many other criminal matters in both state and federal courts without ever having been denied. As such, AFF has every good faith expectation that AFF will be permitted to appear pro hac vice in any state on any state or federal criminal matter. Indeed, the United States Supreme Court has recognized the pro hac vice aspect of the Sixth Amendment right to counsel of one's choice. See United States versus Gonzalez-Lopez, 548 U.S. 140, 2006. Okay, we put that case in there because if you got the least bit of a concern about whether or not we're going to be allowed to appear as local counsel in your state via the pro hac vice rule, you should read United States v. Gonzalez-Lopez. The United States Supreme Court takes your right to select your attorney of your choice very seriously under the Sixth Amendment. But then it continues. However, if for some unforeseen reason a court denies AFF's application to appear pro hac vice in a self-defense related legal matter, the RRG will secure, at the RRG's expense, substitute representation agreed to by client from an attorney qualified to represent the client in the relevant local state. Okay, we've never had this problem, but people have asked, what happens if the local court says AFF cannot appear in court? Well, the answer is you're not left high and dry. The RRG will pay for another attorney who you approve of in your local jurisdiction to represent you. Okay, 6, ethics obligations. A, AFF operates in full compliance with the Arizona Rules of Professional Conduct. AFF is also required to fully comply with all rules of professional conduct applicable in any state in which AFF appears on client's behalf. Client understands and agrees that this agreement is governed solely by the Arizona rules and that AFF is bound by and complies with all ethical obligations and standards of conduct as required by the Arizona Supreme Court in any other state's regulatory authority if legal services are provided in another state, including but not limited to. Number 1, AFF is required to reveal such information to the extent necessary to prevent the client from committing a future criminal act that is likely to result in death or substantial bodily harm. 2, AFF will not assist the client or any witness in testifying falsely. Number 3, AFF will be required to correct any false statement of material fact presented to a tribunal. And Section B, AFF cannot bring or defend a proceeding, assert or controvert an issue unless there is a good faith basis in law and fact for doing so that is not frivolous, which includes a good faith and non-frivolous argument for an extension, modification, or reversal of existing law. A lawyer for a defendant in a criminal proceeding may nevertheless so defend the proceeding so as to require that every element of the case be established. And AFF will withdraw from representing the client if required by the Arizona Rules of Professional Conduct. Client may terminate this representation at any time upon written notice to AFF. Upon client's termination of representation, RRG shall determine in its sole discretion whether it will provide replacement counsel to client under the terms of the RRG policy. Okay, so what's going on in Section 6, ethics obligations? Couple things. First, we're letting you know that we comply, as we were required to, as all lawyers are required to, with all ethics rules, not just in our state, but in whatever state we appear. Number 2, we let you know about some of those ethics rules so you can avoid putting us in a position where we have an ethics problem. And then C, if you decide for some reason you don't want us to represent you, say in the middle of the case, all right, this is something that you're not entitled to change, but maybe, depending on the circumstances, the RRG will pay for a substitute attorney. Okay, that has never arisen in the history of this program, but if it does, that's how it'll be handled. Section D, this agreement shall be governed by Arizona law. If any portion of this agreement is held to be unenforceable, the remaining portions of this agreement shall continue to be enforced. The venue for any dispute regarding the terms of this agreement shall be Maricopa County, Arizona. Any and all litigation over the terms of or any aspect of this agreement must be filed in the Maricopa County Superior Court. Both AFF and the client agree that any litigation filed in any other court shall be immediately dismissed and that the filer shall be responsible for all related attorney's fees and costs. Okay, that's pretty self-explanatory. 7, cooperation. Client agrees to contact AFF as soon as is reasonably practicable, either in person or through a third party, in the event legal representation in any self-defense related legal matter is necessary. B, client agrees to keep AFF informed of current contact information, telephone numbers, secure email addresses, and mailing addresses at all times, in any changes in any information material to the matter. You got to keep us informed about you in the case. C, client acknowledges the best results in this matter can be achieved by the client providing AFF with full, truthful, and complete information concerning all pending legal matters. The client's signature on this agreement attests that the client has carefully read every provision of this agreement and has had all the client's questions answered satisfactorily. Client also attests that the information the client has given and will give to AFF will be truthful and accurate to the best of client's knowledge. If there are any changes in material information or contact information, the client will promptly notify AFF. D, client also understands that client should not use work email addresses, work computers, or public computers such as public library or a hotel, or any email account for which someone other than client has access to communicate with AFF in order to protect the confidentiality of discussions, as email may not be secure on all computers. E, client also agrees to notify AFF if AFF should not communicate with the client via email or regular mail due to a risk of interception of these communications. F, client also agrees to appear in court. In the event client willingly fails to appear in court, client understands and agrees that client has 14 days from the date of client's failure to appear in court to contact AFF to continue representation pursuant to this agreement. Client understands and agrees that in the event client willingly fails to appear in court or fails to contact AFF within 14 days of client's first failure to appear in court, any obligation of AFF pursuant to this agreement is terminated and all benefits are canceled, and the client agrees that AFF may withdraw from representation. All right, if you disappear from the jurisdiction, don't appear in court, don't contact us, we're getting off the case. So don't do that. Section 8. Communications and file retention. AFF may communicate with the client by facsimile, mobile telephone, and email unless other arrangements are made. Therefore, client agrees to keep AFF informed of current contact information at all times. The email address the client provides to AFF must be one for which only the client is authorized to view the contents to avoid waiving attorney-client privilege. Client should be certain that email filters do not block emails from AFF and that the allowable size of incoming emails is sufficient to accept AFF's emails with attachments. It is important that the client retains all communications, including emails and attachments to emails. AFF provides such items to the client as your copy of the client's file. B, AFF retains many documents in electronic format only. These documents may be stored on a remote, secure, third-party server hosted through the internet, the cloud. If the client requires any heightened security measures for the storage or transmission of electronic data, such as for government clearances, please notify AFF. C, client agrees to notify AFF immediately upon the conclusion of any self-defense related legal matter if there are any documents the client wishes AFF to resend to the client. Client understands that AFF will not retain the client's file indefinitely. As such, after the conclusion of any legal matter, AFF may retain a copy of the client's file electronically only for 3 years, at which time it may be destroyed without further notice to the client. So if you want something in the file resent to you, let us know. Happy to send it to you. 9, privacy policy. AFF collects non-public personal information about the client only in connection with providing legal services to the client. AFF will not disclose any information about the matter to anyone subject to attorney's duties under the rules of professional conduct or with client's informed consent. AFF will not communicate privileged information regarding the matter to third parties, such as clients' family members, without client's informed consent, understanding that such disclosures may waive attorney-client privilege. Client shall not discuss attorney's advice or recommendations with anyone, including family members, or on social media sites, as that too may waive attorney-client privilege. 10, acceptance. This is where you certify you've read the RRG policy and this agreement and understand the terms of both. Any questions I may have had were answered by AFF to my satisfaction. I agree to be bound by all terms of this agreement. This is where you sign and say you have no further questions. Okay, we have now covered both your agreement with the AOR Association and your agreement with the Attorneys for Freedom Law Firm. You will now be presented with an opportunity to either say, I got it, I got no questions, check the box, I understand, or I still got a question and I want to talk to an attorney about the fee agreement, in which case this will delay your acceptance into the program with good cause because we want you to understand, but we will then schedule a meeting with you so we can go through and answer all of your questions, because you can't be a member of this program unless you understand everything, including the AOR Association agreement and the Attorneys for Freedom Law Firm agreement. All right, so I know this was a long video. You're still going to get a copy of the RRG policy. It's not absolutely necessary that you read it all through. However, I recommend you do read it. There's going to be a video that you'll have an opportunity to view that I've made that you can go through and get the highlights of the RRG policy so you'll know exactly what's in it so that you can decide. But if you check the box that you got no questions, welcome to the Attorneys on Retainer Association. Welcome as a client of the Attorneys for Freedom Law Firm. You are going to get a welcome email from me. I hope you read that. If you have any questions or concerns about anything, please don't hesitate to reach out to me or my team. We really want you to understand all aspects of the agreement that you're entering into here today. And thanks so much for your attention.